Napoleon Beazley, a 17-year-old just 3.5 months shy of his 18th birthday, took the life of a 63-year-old businessman in Texas merely to steal a Mercedes-Benz. The case ignited a legal battle that spanned nearly a decade, reaching the U.S. Supreme Court and becoming the focal point of a fierce debate on the death penalty for juvenile offenders. Today, we will explore the story from the moment Napoleon Beazley committed his heinous crime to his arduous appeals journey, the meals he chose, his final moments in prison, and the haunting words he left behind. This horrific case began on April 19, 1994, in a quiet residential area in Texas, USA. The victim was Mr. John Luttig, 63, a successful businessman, a pillar of his family, and a loving husband. Mr. Luttig was not just an ordinary citizen. He was the father of J. Michael Luttig, a prestigious U.S. federal court judge. His life was tragically and senselessly ended in his own garage for an unacceptable motive, a luxury car. On that fateful evening, as Mr. Luttig and his wife were returning home, they had no idea they were being watched and that their peaceful life was about to be shattered by an act of sudden violence. Mr. Luttig's death not only shocked his family, but also shook the judicial system, especially when his son's identity was revealed. The perpetrator of the crime, Napoleon Beazley, was born on August 5, 1976. At the time of the offense, Beazley was only 17 years old, not yet legally an adult. He was not a criminal with a history of serious violence, but was drawn into a brutal carjacking plot. Beazley's life is a prime example of how youthful mistakes can lead to irreversible consequences. He committed this crime with two accomplices, Cedric and Donald Coleman, who would later play a crucial role in bringing him to justice. What could possibly drive a teenager to take a life so brutally just for a car? On the afternoon of April 19, 1994, a horrifying scenario unfolded in the garage of John Luttig's home in Texas. Napoleon Beazley, along with the brothers Cedric and Donald Coleman, ambushed Mr. Luttig and his wife. Their target was clear: Mr. Luttig's luxurious Mercedes-Benz. Beazley, at 17, was the one who pulled the trigger. He coldly shot Mr. Luttig twice in the head to steal the car. This act not only demonstrated brutality, but also a terrifying disregard for human life. Not stopping there, Beazley also shot at Mr. Luttig's wife, but fortunately she survived by playing dead. In that moment of chaos and terror, Mrs. Luttig showed extraordinary courage, keeping her composure to save her own life, while witnessing her husband being brutally murdered before her eyes. After the crime, Beazley and his accomplices took the Mercedes and fled. This savage carjacking shocked the community not just because of the nature of the crime, but also the perpetrator's callousness. Could a teenager become this brutal just for a car? Immediately after the murder, police launched an investigation. The focus was on tracking the stolen Mercedes and the suspects. Thanks to Mrs. Luttig's testimony and evidence collected at the scene, the police identified Beazley and his two accomplices, Cedric and Donald Coleman. All three were arrested shortly after the crime. During the investigation, Cedric and Donald Coleman decided to cooperate with the prosecution, testifying against Napoleon Beazley. Their testimony became crucial evidence, strengthening the case against him. Both Coleman brothers pleaded guilty to federal carjacking charges and were sentenced to 43.75 years and 40 years in prison, respectively. Additionally, they pleaded guilty to first-degree murder in state court, and each received a life sentence with the possibility of parole after 40 years. Their cooperation, possibly to mitigate their own sentences, ensured that justice would be served for the Luttig family, especially for the direct perpetrator, Napoleon Beazley. But would the testimony of accomplices truly convince a jury to impose the highest penalty on a juvenile offender? The trial of Napoleon Beazley was an arduous legal journey that lasted nearly a decade and captured the attention of the entire United States. The case was complicated by the victim John Luttig's connection to the justice system. He was the father of J. Michael Luttig, an influential U.S. federal court judge. This created a rare legal situation at the U.S. Supreme Court. During Beazley's appeal to the Supreme Court, 3 of the 9 justices had to recuse themselves from considering the case due to personal relationships with Judge Luttig. Justice Antonin Scalia recused himself because Judge Luttig had been his clerk, while Justices David Souter and Clarence Thomas recused themselves because Judge Luttig had been involved in their confirmation processes to the Supreme Court. This left only 6 justices to review the case, an unusual circumstance in death penalty cases. Beazley's appeal journey began on June 3, 1997, when he filed a petition for a writ of habeas corpus in a Texas state court. After numerous hearings and reviews, his petition was denied in October 1997. Undeterred, Beazley filed with the Texas Court of Criminal Appeals in January 1998, but was also rejected. In October 1998, he took his case to the U.S. District Court, which also denied his petition. Although the U.S. Supreme Court declined further review, in September 1999, the Federal District Court allowed Beazley to file a new appeal in December 1999. On June 1, 2000, Beazley filed his appellate brief with the U.S. Court of Appeals for the Fifth Circuit. However, in February 2001, the Fifth Circuit denied his writ of habeas corpus. Although Beazley continued to file for a rehearing, it was also denied in March 2001. On March 30, 2001, Beazley's execution date was set for August 15, 2001. However, the legal battle was not over. In June 2001, Beazley filed a petition for a writ of certiorari with the Supreme Court regarding the denial of his federal habeas corpus. On June 28, 2001, he also filed for a stay of execution with the Supreme Court. Notably, on August 13, 2001, the Supreme Court voted 3-3 on Beazley's request for a stay. This tie meant the decision of the Fifth Circuit Court of Appeals was upheld, denying Beazley's stay request. It seemed like the end, but on the very day of his scheduled execution, August 15, 2001, the Texas Court of Criminal Appeals unexpectedly granted a stay of execution. This stay, however, was only a brief delay. On October 1, 2001, the Supreme Court once again denied certiorari. On April 17, 2002, the Texas Court of Criminal Appeals lifted the previous stay of execution. And then on April 26, 2002, Beazley's final execution date was set, May 28, 2002. In his final weeks, Beazley and his lawyers made every effort to find a last chance. On May 7, 2002, Beazley filed a clemency petition with the Texas Board of Pardons and Paroles. He even filed a supplemental petition on May 13, 2002. On May 17, 2002, Beazley and 3 others filed a lawsuit in U.S. District Court claiming inadequate legal representation. However, on the same day, U.S. District Judge Hayden Head dismissed the suit. A notice of appeal was filed. On May 21, 2002, the Fifth Circuit Court of Appeals affirmed the lower court's ruling denying an injunction against the execution. Finally, on May 22, 2002, Beazley filed a petition for a writ of certiorari with the Supreme Court, one last time, his final hope. The fateful day of May 28, 2002 arrived. That evening, the U.S. Supreme Court voted unanimously 6-0 to deny Beazley's habeas corpus petition. With no hope left, Napoleon Beazley was executed by lethal injection. Regarding Napoleon Beazley's final hours, this is a particularly important part of his story. In the 24 hours before his execution, Beazley was allowed final visits with his family and lawyers. He spent time writing letters and saying his goodbyes. According to the observations of guards and the chaplain, Beazley's mood was described as calm and seemingly accepting of his fate, though he could not hide his sadness and disappointment. He had a final meeting with the warden and reviewed the execution procedures. Criminal psychologists often note that this state after years of appeals and waiting is a sign of surrender. As for his last meal, specific information about Beazley's food choices was not as widely publicized as in some other cases. However, per regulations, he would have been provided a special meal upon request. Some unverified sources claim he ate cauliflower egg soup beef and a glass of orange juice. While his exact choice is unknown, the last meal often carries deep personal meaning, perhaps a dish reminiscent of childhood, a simple favorite, or something symbolic. In the context of awaiting death, these seemingly small choices reveal a part of the condemned psychology, a final moment of personal freedom before facing their sentence. When taken to the execution chamber at the Huntsville Unit, Texas, Napoleon Beazley delivered haunting and controversial last words. With witnesses present, including the victim's family, media representatives, and prison officials, the moment was incredibly tense. Beazley's last statement was a long speech expressing remorse, but also filled with philosophical reflections on justice, forgiveness, and the flaws of the system. He said, "The act I committed to put me here was not just heinous, it was senseless. But the person that committed that act is no longer here. I'm not going to struggle physically. I'm not going to yell, use profanity, or make idle threats. Understand, though, that I'm not only saddened but disappointed that a system that is supposed to protect and uphold what is just and right can be so much like me when I made the same shameful mistake. If someone tried to dispose of everyone here for participating in this murder, I'd scream a resounding no. I'd tell them to give them all the gift that they would not give me. And that's to give them all a second chance. I'm sorry that I'm here. I'm sorry that you're all here. I'm sorry that John Luttig died. And I'm sorry that something in me did this in the first place. Tonight we tell the world that there are no second chances in the eyes of justice. Tonight we tell our children that in some instances, in some cases, killing is right. This conflict hurts us all. There are no sides. The people who support this proceeding think this is justice. The people who think that I should live think that is justice. As difficult as it may seem, this is a clash of ideals, with both sides committed to what they feel is right. But who is wrong if in the end we are all victims? In my heart, I have to believe that there is a peaceful compromise to our ideals. I don't mind if there is no compromise for me, as long as there is for those who are yet to come. There are a lot of men like me on death row, good men who fell to the same misguided emotions but may not have recovered as I have. Give those men a chance to do right. Give them a chance to undo their wrongs. A lot of them want to fix the mess they started, but don't know how. The problem is not in that people are not willing to help them find out, but in the system telling them it doesn't matter anyway. No one wins tonight. No one gets closure. No one walks away victorious. These words, delivered in a calm yet powerful tone, were profoundly shocking. They were not just an apology, but also a deep indictment of the justice system and a call for second chances. Immediately after he finished speaking, the lethal injection process was carried out quickly, and Napoleon Beazley was pronounced dead on the evening of May 28, 2002. The death of Napoleon Beazley sparked a fierce debate between supporters and opponents of the death penalty, especially for juvenile offenders. Many human rights organizations, such as Amnesty International, advocated for clemency for Beazley. Due to his age at the time of the crime, he was only 3.5 months from being 18, and their general opposition to capital punishment. Beazley's case became a symbol for those who believe that sentencing individuals who were under 18 at the time of their crime to death is a violation of human rights and morality. This case had a profound impact on U.S. law. Ultimately, in 2005, the U.S. Supreme Court, in the case of Roper v. Simmons, officially banned the execution of offenders who were under the age of 18 at the time they committed their crimes. Napoleon Beazley was one of the last juvenile offenders executed in the United States before this historic ruling was issued. This brought about a major change in the criminal justice system, ensuring that young people, even those who have committed serious crimes, have the opportunity for rehabilitation and a different future. The case of Napoleon Beazley is a multifaceted tragedy reflecting complex questions about justice, punishment, and the human capacity for rehabilitation. It is a reminder that even in the most brutal crimes, there are complex human stories behind them, and that society is still grappling with finding the line between retribution and forgiveness. This story is not just about the death of a businessman or the execution of a teenager, but about a nation's ongoing struggle to redefine the meaning of justice and compassion.